Greetings, my name is Hamid Omar from Hamid and Associates Advocate, and today we are going to talk about the article which I did in relation to the Crops Act, which was titled Airtight or Water Leaking of the Crops Act. So basically this one is an analysis of the Crops Act that came into being on 14th January 2013. So the Crops Act came on to be so as to ensure economic recovery and wealth creation in Kenya. The brief history of it was that it started in 2003 when the late President Mwai Kibaki came into power. So when he came into power, he saw that the agricultural sector, though is a builder of the economy, had some issues with it. For example, there are too many laws, there are institutional failures, there was lack of credit, there was lack of technology. So to solve this one which was stated in a paper that was published in 2003 called the Economic Recovery Strategy for Wealth and Employment 2003 to 2007. So the aim there was to have one main law, then that one main law will establish a main body or authority. So on 14th January 2013, that's when the Crops Act came to be, and the Crops Act now established the Agricultural Food Authority, now that was to head the Agricultural Department. So one main issue noted is that the Crops Act under Section 5 was that it was to apply to scheduled crops. So now the question that was asked was, what is a scheduled crops and what criteria or what parameters are used to determine the crops that are tabled there in the first schedule as scheduled crops. So in the article, I've given the first schedule and stated all those crops that are there stated as scheduled crops. So that was it, and the article can be found at Academia and also at Hamid by the name Hamid Omar, and also at LinkedIn at Hamid and Associates Advocates. So basically, the main issue was that by it not having a clear definition of what a scheduled crop is, then we say that, when you say a particular section of the law is infringing a particular right, as a law in the law society or the law fraternity is that you must state how that law is affecting somebody else. So you must not only say the law is not respecting this particular right, but you must go ahead and say, how does it affect another person, or how does it affect you directly? So on this one, there being no definition of what a scheduled crop is, we say that it infringes on the national value and principle of Article 10, specifically on the rule of law. On the rule of law, one of the main agenda of the rule of law is that the law should be certain, and where it's not certain, then there's no rule of law. That's how it is. And in the article, I've stated some cases there in like two, which is into that agreement. So basically, on the rule of law is uncertainty, and where the law is not certain. So you see on an example here is that the scheduled crops is not given. There is no parameters to give or state what a scheduled crop is. Like, we don't know. You just see a list given. Whap, just like that, surprise, there's that list. So now you have to ask, for example, in that list, some crops are missing. For example, there's Napier grass. Napier grass is used by livestock farmers to do dairy farming, or is it goat meat or beef meat? So there is Napier grass. There is the crop called moringa, which is also not there. Then there is also pomegranate, which is a fruit, which is missing there. There is aloe vera, which is missing. And then there's a clear distinction between they sometimes grouping fruit tree together, and then in other instances, for example, pawpaw and mango, they have, in that second last section, they have grouped fruit etc and fruit tree as others. And then the other examples where the a fruit tree is labeled differently, for example, like jojoba, or what we call it mkunazi. So we ask, where does pineapple stand? Like, that's the question that we ask, like, where does pineapple stand, because it's not there. So basically that's it. And on the issue of, now first I will state the rights that are being infringed, and then I'll state, because for all of them it's the effect is uniform. So now we have talked about Article 10 on the rule of law, on the principle, the main rule, which is certainty of law. Then there's Article 27 on the right of equality. On Article 27, people should be treated equally. Thus, nobody should feel infringed, like they're not being treated equally. And one of them of being treated equally, there's some ground, like somebody should not feel discriminated upon. Concerns and belief. Concerns is when you believe, concerns is when you say is what you think. Concerns is what you think is right or wrong. And then belief is what you think is true. So concerns is what you think is right or wrong, and then you make a decision. And then on the term of belief is the truth that stands there, like, or the belief. So, or the knowledge that you have. For example, let's say on the concerns, like, let's say you decide you by analyzing the land that is there, you say, I'm going to plant maize. You have made the decision, like, that's what you think is right or wrong depending on the situation. And then the belief is the knowledge that you have, and say, in this area that I'm in, maize does not sell nicely. The crop that sells maybe is apple or beans. So now these ones are two aspects, like right and wrong. So for example, now if maybe the farmer says the right or the wrong decision that to make is that on this farm of mine I have to grow aloe vera, and then the knowledge is that aloe vera sells well in this community of ours. You see, those ones are two grounds which the Constitution says that you should not discriminate somebody upon. But now, on this part, on their having no clear definition of what a scheduled crop is, there is no reason. You see, this farmer is not benefiting from that situation. How are they not benefiting? This is because from the Crops Act, you'll see that in Section 7 and Section 8, if I'm not mistaken, is that being scheduled crops is that it comes with advantages. The government pumps in money, there is a department to it, the government promotes it, the government ensures the transport system of transporting the goods from the farm to the market is adequate, they market it internationally, so there's the impact of export, and then there is them establishing market structures on the ground. So it makes things much easier, like there's that support system. So now on this action now of not having a clear meaning, it's like there are other farmers who are missing out. For example, now I've said pomegranate, there is moringa, there's aloe vera, there's also pineapple. So that one is on the ground of Article 27. On the ground of Article 40, Article 40 is on the right to property. And to get a brief meaning of what property is, we look at Article 260. So Article 260, is, for example, in Article 40 specifically, is that One, the right to property should not be prevented because of the grounds articulated in Article 27. Now we'll go back to concerns and belief. So they should not prevent the enjoyment of the right to property. That's how Article 40 is framed. Like the government should not do that. Now, we have to look Article 40 on the definition of what a property is. You'll go to Article 260, whereby now at B you'll find there is the definition of goods or property. Then the issues of goods will go to Section 2 of the Sale of Goods Act, whereby there now we'll see industrial growing crops. Now that's when now the crops that we are talking about comes in. So in basis, it's that these crops become now property. So, and now property, it has these bundles of right. You have the right to own, to sell, and something like that. You have like 8 bundles of right, or the bundles of sticks. You have the right to own it, to benefit from it, to sell it, somebody to inherit from you. Then there's that protection. So basically, there are those bundles of sticks, 8 of them. You'll find them in the article. This one is just a summary. So basically, that's it. So now, how do you say? Remember, the main argument is the same. The effect it has is that it leaves out the other farmers who are not defined, who are not, whose crops are not there in the scheduled crops. So that's the main effect it has for all these fundamental rights. That's the effect, the side effect it has to the farmer. Like it moves them out from the benefits that the government gives to the crops that are stated in the scheduled crops. And then the other fundamental right that is being infringed is on there's Article 10, Article 27, Article 40, then there's Article 43 on social economic rights. This one, the social economic rights is that they are progressive in nature. So these ones we have rights like the right to health, right to education, right to food and water, right to food and freedom from hunger. There's right to water, right to reasonable health care. So basically, on this right is that like the government in, was it Article 2021 to 2021 thereabout in the Constitution of Kenya 2010. So basically is that the government can have reasons. They can have reasons and say that they don't have enough resources to ensure the enjoyment of those rights. It's a progressive right. And then the other thing is that the decisions of the government to ensure they follow to those economic and social rights is that that decision cannot be challenged for reasons that another decision could have been reached. But there is one principle therein: there has to be standards. And standards, according to the Black Law Dictionary, means rules or reasons. Rules or reasons. So you see, we are not going back to what do you define as scheduled crops. So what's the definition of scheduled crops? It's not there. So are there standards? There are no standards. So now if you say that, now you just argue and say, no, it cannot happen. So it infringes on also Article 43 on social economic right. But then on this one is a rather tricky one because you have the floodgate theory. Like considering this one is a progressive right, it should not be such that like people should come to the court and say, there's this right infringed, there's this right infringed, because at the end of the day, we have to prevent many two cases being tabled against the government, because at the end of the day, the government has to work. So now if there's every reason, like a small reason somebody sues the government, a small reason sues the government, you see there's that time being taken by the government to defend these cases, thereby reducing their time allocation in service delivery and goods and provisions of goods. So that's it. So on this Article 43, it's rather risky, but still there. Then there's Article 46 on consumer rights. Like on consumers, is that by consumers is somebody consumer Article 46 on consumer rights. A consumer is a consumer also include a citizen. A consumer also include a citizen. And this one can be found if you read in the Consumer Rights Act. It's there in the article. So this one is just a summary. So, and consumer rights usually apply to both the private and public sectors. The private and public sector. So the public sector, because both of them are in the provisions of good and service delivery. So they are not taken out from the provisions of Article 46. One of the provision is that there should be given reason. Oh, and then I also forgot on the economic and social right is that it's infringing on the right to food and freedom from hunger. This is because if, for example, if to many farmers, that's their source of income. So now remember, the government usually supports these scheduled crops. They give them support money-wise, market, transport system, market infrastructure, export marketing. So now for a farmer that maybe grows moringa or aloe vera or pomegranate or napier grass, you see, by them not being there as scheduled crops, you see, you have cut them, like there's that source of income coming to them. And the source of income is what brings food to the table. So now, if you cut off that source of income, you definitely are inviting hunger. So basically, that's on the economic and social right on basis of food, the freedom of the food, and the right to food and freedom from hunger. So that's the economic and social right. And then on the consumer rights now is that a consumer, by the Consumer Protection Act, by the definition based there on who a consumer is, a citizen is also a consumer. And the consumer rights applies to both public and private sectors. And one of the information needed there is that there has to be the reasons being given. Reasons have to be given to the goods that are, let me read the main act. The information necessary for them to gain full benefit from the goods and services. So you see here, like there's no full information to a citizen to know like what is these scheduled crops so that they can enjoy the full benefit of those services. You see, the reasons has not been given. So now there's not that full enjoyment because now if a citizen, I want to grow moringa and now like I have to be given reason of what scheduled crops are so that I can adjust myself. So that's one of the other reason, consumer rights. Then the last one is fair administrative action. Is that one thing to be noted is that the parliament is also included in the fair administrative action. This one was from an article I got from Katiba Institute. That one was my understanding. So anybody can have a different understanding, but from what I understood, that's what it is. So for fair administrative action is that the right to fair administrative action is that one should be given reasons thereof. But now on this end, there's no clear reasons on what scheduled crops are. Thereby now they're limiting that person to that full enjoyment of the benefits that are stated therein. For example, to these credit facilities, to the marketing, to the promotion. So basically that's it. And then now on the conclusion, I stated that the Crops Act came to be is a noble adventure, but it's like it is a road full of potholes because if you read the article that I've written, which you can find at Academia and also at LinkedIn at Hamid and Associate Advocates, is that it's like there's this boxing match between the various articles and the various principles of national values. For example, there's the boxing match between Article 10 on the rule of law, specifically on the rule of law. Now you go under it, there is on the rule of law, under the rule of law, there's that rule that of certainty of the law. So there's no that certainty. So it's like a boxing match already there. So it's like fighting now. Then there's Article 27 on the right to equality, Article 40 on the right to the protection of property, of the right to property, Article 43 on economic and social rights, Article 46 on consumer rights, and Article 47 on fair administrative action. So at the end, we say, I ended, the end was like this. If the inner child theory is anything to go by, we all like games. So in this example, from the article that I've written and from this brief summary explanation of what the article is, if we flip a coin, in our case here, what do you think will happen? Will it showcase the heads or the tail? So yeah, that's it. So that's me, Hamid Omar from Hamid and Associates Advocates, and thank you very much for listening.